Thank you. Thank you. I'm honored to be here. I met some of you at your annual conference last year where you asked me to be a plenary, and so to be here is quite remarkable, if for no other reason that no one ever asked me back. Where are my Duluth people? Duluth? Okay, see some of them. I think we're missing some of them. They asked me to start off on a bad foot, but let's just get it out of the way. They asked me to apologize to the rest of you last night. As you alluded to, your networking suite was very successful, apparently, because, as many of you know, at 3 a.m. this morning, the Duluth delegation was knocking, banging, kicking on my door, grabbing at my door latch, falling over each other, yelling and screaming, and finally at 3 a.m. I had to get up and let them out. So for those of you from Duluth that are able to make it in this morning, I congratulate you. I'm going to tell you what I would tell the third-year law students when I was teaching at the University of Richmond Law School, their litigation clinical. The very first day, the students are always a little nervous. They're wondering what kind of learning environment this is going to be. So I'm going to make the same promise to you in this room that I made to them. Please know that in this room there is no such thing as a stupid question or stupid answer. Just stupid people. Okay, let me not. That goes over well in Utah. Today we really have an opportunity to have as much a discussion rather than a monologue as you can with 270 folks. But I want to make sure that we do have an opportunity to exchange ideas and differences of opinion, because the topic we're talking about today is absolutely too important not to give you an opportunity when you're having a rare occasion to be able to sit and talk. So I promise you this morning there are going to be ample times for you all to sit and talk, work in your groups, and hear back from you, because again, it's very, very important work. Let me just give you a very, very quick roadmap of where I would suggest we might want to go today. And believe me, some of you who've known me for years, I'm quite comfortable handing over the reins and y'all going where y'all need to go. I'm absolutely comfortable with that, and I encourage that. But essentially, I'd like to address, based upon my experience as a court consultant the last 10 years and being a director at now 2 state Supreme Court AOCs, and as a former trial attorney for many years. Bringing all of those experiences together, I have made some observations and some conclusions which you may not agree with. My experiences may not be what you're experiencing in your court in your state. But having been in over 40 state courts working with them, there's some walk-away truisms that I believe go to the heart of what we're going through right now. And the 4 takeaways, if I could just condense my experiences, not that it's right, but just my observations, is that when we talk about coping strategies under the new normal, which is a term that is really getting under my skin, when we talk about coping strategies, one of the things that perturbs me so much when I go to some states is that consultants have said, okay, you need to re-engineer what you're doing. That's another term that I think is appropriate, but is now getting under my skin. Before we get deep into the weeds, in order to have coping strategies, before we start trying to fix and make a whole new or a better mousetrap, the very first strategy that we're going to talk about today is we have to revisit who we are as an institution. What are our core values as an institution? What business are we in? Why are we the most unique institution, not just among the 3 branches of government, not just the most unique institution in our country, but the most unique in the world that countries are trying to emulate every single day. So before we start talking about re-engineering and dealing with a new normal, we have to understand that being adaptive and transformative is not some hot off the press new technical innovation or some new management theory. The very first thing we have to do is we have to revisit who we are and why we're special, because transformation is always tied to values and getting commitment towards who we are as an institution. All the other bells and whistles don't matter a diddly's whit if we don't start by revisiting who we are. So we'll spend some time this morning talking about that. The second thing that I would respectfully suggest that we can walk away from all of the collective experiences that courts have and are enduring right now is that we ask ourselves the following question. Why is it that some courts facing the same or similar adversity as other courts, why is it that they're able to adapt and transform? What is it about them that's different from those courts that just can't seem to do it? And those that can't have a lot of doggone reasons, have a whole lot of obstacles, and they've got a lot of excuses to explain why they can't. But that begs the question, why is it? What are the characteristics of those adaptive, transformative courts that are able to do that? We're going to examine those characteristics. The other thing that I would suggest that we look at is I guess it goes under the auspices of change management, which it's used so much it really has lost its meaning. But what is it that we can do during the new normal that allows us to change? What are some basic change management strategies? And one of the things that I will also want to talk about if we have time is, what is it that's really holding us back in adapting and transforming? And I have to go back to, quite frankly, and I'm going to save you all like $10,000 right now, because that's about how much I paid my shrink years ago to get through some bad times. And one thing that I learned from her is that if we understand what the 4 basic fears are that are shared universally by all humans, if we understand what those 4 human fears are that are innate, that are resurrected during trying to deal with a new normal, we can actually develop strategies, coping mechanisms, that allow us to get through this new normal. So that's going to be the general pattern that I'm going to try to stick with today. But the very first thing I want to ask you is, what does the term new normal mean to you? Or what does it elicit from you viscerally? Anybody? What does it mean? Remember, no right or wrong answers. Electronic?
Electronic everything.
Okay. Less staff? What else? Yes? Pressure to add new services. While they're taking money away, they want us to do more. Which takes us to my next point. Ernie Friesen was the first person I heard say the following. This is, gosh, I hate to age Ernie here, but probably not quite 20 years ago, we were having this same discussion. And he said, we can't do more with less, we can only do less with less. And this is what irks me about the new genre of re-engineering courts or coping with the new normal. It's very real. I'm not saying it's not. I'm not diminishing the reality. But the thing is, we have been re-engineering our courts and dealing with the new normal for 30 years. I would make the argument we've been dealing with the new normal and re-engineering our courts since Roscoe Pound's 1906 speech to the ABA conference, talking about the popular dissatisfaction with the administration of justice in the courts. which led to the first reunification of courts movement. We can go back to the 70s and 80s when we started completely reorganizing our state and local courts through the auspices of reunification. And all of the tremendous re-engineering that was involved with that. Look at the problem-solving courts, the specialty courts that we've designed. 20 years ago, when I was practicing law, I would never in a million years say courts are a flexible, adaptive institution. But it was about that time that we started really asking ourselves, what business are we in as an institution? If you look at the advent of problem-solving courts, specialty courts, all the people that have been served by them, that didn't just happen, that didn't fall out of the sky. It happened because we have been re-engineering our courts and paying attention to what business we're in for years and decades and decades and decades. And so it perturbs me when people start saying, oh, well, now, look, the courts are having to start problem solve and re-engineer. Let them cope with a new normal. We've been doing it. And we should be proud of it. And the second issue I have with the notion of re-engineering courts, even though we're having to do it by necessity, is because every re-engineering effort ultimately has a ceiling. You can't get but so much blood out of a turnip. At some point, to get that added value, we've got to remember who we are, what are our core values. So what might our coping strategy be? Before we re-engineer, we need to revisit, as you've heard me say. We need to know the difference between static and transformative courts and being able to identify characteristics of both. We need, and always have been, this is nothing new, but we need to create high-performance court teams. How do we do that? And lastly, apply proven change management strategies, not just de jour, what's the hot management topic, but proven change management strategies. So let's begin revisiting who we are. I am going to make the case that our courts are not only the heart and soul of who we are as Americans, it's the heart and soul of the world. Let me make that case for you, because we don't talk about it enough. And re-engineering glosses over this. I'll tell you a true story. Years ago, when I was a consultant to the dean of one of Virginia's law school on a special project, one of the brightest constitutional scholars I've ever known. It was very intimidating to be around him, even though he was one of the most down-to-earth, kind folks you'd ever meet, Dean Rod Smolla. So Dean Smolla and I had to take an Amtrak ride from Richmond to Washington, D.C., because that's where the project we were working on. And so here I am. I've got this daunting task. I've got to sit by truly one of the most brilliant legal minds in the United States and carry on a conversation with him. So I said, okay. The night before, I go, what am I going to talk about? What am I going to ask him? So I said, well, first, I know he's a big Cubs fan. So I've got two options. I can say, Rod, how do you think the Cubs are going to do this year? Or, what do you think the greatest contribution the courts have made to society is? Like an idiot, I asked him the second one. But his answer stuck with me to this day. And it goes exactly to why we're the heart and soul of our governance, our country, and the world. He says, Tom, for the first time in human history, when the founders started our country, we made a very unique pact that had never been done, not even with the Magna Carta, where the government said, we want your permission to form a republic. And here's the deal, folks out there in America. If you allow us to form this republic, we guarantee you that the first order of business on the very first day of our very first Congress, we're going to take up the 10 amendments to the Constitution, and we are going to grant every single person that lays foot on our soil inalienable rights that no other human being has ever had, and also to avoid tyranny and to provide opportunity. And here's the deal. You don't think we're serious? If we violate any of those, if our government ever, from this day forward, violates any of those inalienable rights, 10 amendments, you get to not only sue us, you put us in jail. And we are going to be judged by your peers. I thought that was pretty compelling. And unfortunately, and by the way, that's consistent with what probably the greatest Chief Justice of the United States courts, John Marshall, said, of the three branches of government, the judiciary is the only one that comes to the heart and home of every single person. It passes on everyone's reputation, property, their life, their all. No other branch can say that. No other public or private sector organization can say that. No other institution can say that. And I'd forgotten Rod Smola's and, frankly, Justice John Marshall's words until about 2 or 3 years later. My wife and I took a little vacation down to the Florida Keys. My wife and I are Virginia Tech grads. We're big Hokie fans. Don't hold that against me. So we were down there to watch Virginia Tech play Miami Hurricanes down there, obviously in Florida. So being a Virginia redneck, I never go anywhere without my fishing pole. So before the game that Saturday morning, I said, I'm just going to go walk right out and throw my line out into the water. And as all of you know, the Keys, it's just, one bridge just connecting another little island or isthmus key after another. So I'm standing under the shade under one of these bridges because even in the morning it was hot as blazes. And I throw out my line, and as soon as my lure hits the water, I hear a helicopter. I hear the Coast Guard sirens. I hear police vehicles coming, and I'm going, oh my God, they take fishing without a license down here. Seriously. Excuse me. And then, just a moment later, behind one of the abutments, I saw what looked like were the vestiges of a beaten to heck raft. And people crawling out of it, desperately trying to set foot on some rocks, literally not as far from here to that wall to me. And they were scrambling to get to the safety of the rocks. Some of them made it and started taking off running. One of the women that stayed apparently had her child bundled up in cloth and clothes, so she stayed. It was quite a sight to see. But unfortunately, in one of my more calloused moments as an American, and as someone who serves the courts, my mind went right back to the Virginia Tech Miami game. So we came back that night from the game. I get up Sunday morning, same little place, Alamorada, Key Largo. I don't know if any of y'all from Florida. A beautiful little spot. I'm reading the local newspaper, having my coffee, waking up, getting ready to fly back to Richmond, Virginia. Front page. This is a family of refugees from Cuba. The child died. The grandfather had been lost at sea. All in an effort because they wanted to touch foot on American soil because they knew that that would give them inalienable rights that no other human being in the history of the world has ever enjoyed. And this is not a comment about illegal or legal immigration. It's about who we are as a heart and soul of not only of our governance and our country, but of the world. People are doing this every single day. By the time you leave today, if you believe in the Naturalization and Immigration Service, over 100 people will die giving their lives trying to get into this country. Tens of thousands of more are giving up everything, including saying goodbye to their family, their friends, their property, their livelihood, to legally come here, forfeited everything to start all over. And ladies and gentlemen, with all due respect to our legislatures, state and federal, and to our executives, our good governors, and our good presidents, they don't come here because of them. They come here because of the courts. Because they also know that if they get here, their right to pursue a livelihood, to be safe, not to be oppressed, will fall right in their laps. And that to them is worth giving up everything. So when we start talking about re-engineering, let's remember who the hell we are. We are the best that the best has to offer. Now, if you're just thinking I'm blowing smoke, and gosh knows, some of you who know me, Kevin goes back with me as a friend and a colleague for over 20 years. He knows I'm not above blowing smoke. But this just happens to have the added benefit of being true. Almost all of you by now are probably familiar with Tom Tyler's research. For some of you who don't, please recall he did groundbreaking research, interviewing, surveying thousands of misdemeanor and many small claims folks. And he found out that, here's the punchline. I won't bore you with the empirical research. But if you've got time, I'll tell you, buy the paperback, Why People Obey the Law by Tom Tyler. Why People Obey the Law. Skip all the empirical stuff and go to the executive summary, and it is a confirmation of everything I'm about to tell you. His research showed that even those who were convicted of misdemeanor crimes within a high degree of scientific reliability said, you know what? I thought the process treated me fairly, and he didn't put it this way, but this is my lowbrow way of making sense of what his research says. People would rather be listened to and understood than agreed with. And those who were, through the process of going through the courts, even when they when they were convicted, they gave incredibly high marks to their court. And here's the kicker. It wasn't the judge's outcome. It was not the judge's decision that was determinative of those folks coming to that conclusion. You know what was? Their interaction with you. When they felt the process treated them fairly, when they were told where to go, what their options were, even after being convicted, receiving help, saying, here's what you're right, here's how you file a right of appeal. Those who experienced that gave the courts extremely high marks. So it is the process, not the outcomes, that determine how folks view us as an institution. So when we do talk about re-engineering, we know that makes a difference in the process. So it is a worthy conversation to say, how can we re-engineer? How can we continually improve? So, what business are we really in? When I was sitting down with the Chief Justice Carrico, thrice removed Chief Justice of the Virginia Supreme Court, and I was sitting down with the Armenian Supreme Court delegation. And he and I gave some presentations, and through their interpreter, the Chief Justice of Armenia, the very first question out of his mouth was this, not to me, but to our chief. How is it, Mr. Chief Justice, that you can get your people to obey your unpopular opinions when you have no army to back it up? That was the one question they wanted to ask more than any. And then all of a sudden, all of this that I've been blithering about came into focus. How unique it must be, how alien it must be for other countries to look at us inside a fishbowl and go, my God, how do they do it? But we do. And we do it every day. But to be adaptive and transformative, to deal with the new normal, again, the very first question we've got to ask is, what business are we really in? And by doing that, it allows us to reprioritize our core functions. But we can't re-engineer or reprioritize if we don't continually ask ourselves what business we're in. I'll give you a true example. In 1950, there was a company that launched an ocean liner that was supposed to be the fastest in the world. And in fact, it broke the world record in the short amount of time that it made it from England to New York City transatlantic. It beat the world record by several days, which was earth-shattering. That industry was still in its hangover from celebrating when almost 2 days later, top of the fold headline, New York Times, the first jet airline commercially flying passengers from London to New York made it in hours. Hours. Look at, and so the industry, the ocean line industry go, oh my God, you know, we thought we got big for our britches because we thought we broke this long-standing record, and now they do it in hours? Are we now meaningless, irrelevant? So think about that industry for a second, because in the 1970s, during an expo, World Expo, there was a huge amount of space devoted just to watchmakers. And that, at that time, in the early 70s, was another way of saying the Swiss watchmakers. Because the Swiss had a 90% monopoly of all quality watches made in the world. They had no predator. They had no competition. They were the 600-pound gorilla. During that expo, a little startup company by the name of Texas Instruments wanted to put up a display next to them. The Swiss watchmakers went to the expo president and said, get these jacklegs out of here. They have no business even rubbing up against our shoulders. And they were removed from that exhibit. 3-4 years maybe later at the most, the digital watch had well over half of the watch market in precision watches made in the world. And the Swiss watchmakers were going, what happened? What happened was they didn't do what the ocean liner industry did. The ocean liner industry in 1950 asked the question, what business are we really in? Because we're going to have to reprioritize what we're doing if we're going to stay relevant and even exist. So why is it that we're seeing, you can't hardly throw a stick without hitting a cruise ship? In fact, one, I think it was 2 years ago, one that was twice the size of the Queen Elizabeth II was launched. And that industry is very solvent. What was it that they said? They go, what business are we in? They said, we're not in the business of transporting folks anymore. We're in the entertainment business. We're in the relaxation business. Vacation. They re-examined and reprioritized. The Swiss didn't, and I bet you hardly any of us in this room knows a person that owns a Swiss watch. So now I'm going to ask you a question. I told you up front that I was going to give you an opportunity to talk and then I want to hear from you. I know most of you all, if not every single one of your courts, has had to have a discussion, okay, how we're going to reprioritize. What are we going to do? And I'm going to ask you what criteria you applied when you had to reprioritize something. But let me give you the example of the New York City family courts. Up until about a year ago, I had been a consultant with them, working with the New York City family courts on a host of issues. The chief family court judge calls me up one night, 7 o'clock at night, and says, Tom, can you get up here in the next week or so? And I go, of course. I had no life. Of course I'll be there. So I go, well, what's up, Judge? What's going on? This is really unlike you all to give me a call like this. We do it, well in advance. She goes, the mayor is just, anybody from New York City family courts here? Good, I can make stuff up. She said, the mayor has now issued an edict allowing all city employees, including courts, to take advantage of an early retirement incentive. We believe, we don't know, but we think that over the next 6 months we're going to lose 30% of our workforce. You know the demographic bubble out there as well as I do in the courts. You're seeing it. So this shouldn't be a surprise. It turned out that within 6 months it was more like 50%. It's a tsunami wave. My suggestion to them would be, and was, treat this as a continuous operation of courts problem, a coup. Treat it like a tsunami wave, treat it like a bird flu virus, but reprioritize. And they go, well, how do we do that? I go, you've got to decide what the criteria are. So now I'm going to ask you, those of you that have had to reprioritize, what criteria did you use? Was it constitutional mandates? Was it what the criminal code required? Was it because federal grant money said you had to do X, Y, and Z? I want you to take a few minutes, and then I want to hear back from you. What were the criteria you applied? And I'll get back with you in 5 minutes. All right, I'm going to bring you back, please. I'd like to hear some of the discussions at your table, even if they weren't really relevant to the question, especially this group over here. I got to find out what y'all talked about. That was just too rich over here. I will come to you with my little mobile mic. So anybody, what were some of the things that were discussed at your table? Okay. Thank you, Kevin.
Don't want to leave you hanging there.
Thank you.
Our top three were, in terms of criteria you're asking for, is looking at legal mandates. Secondly, the societal importance of certain discretionary services. Even if there was no mandate for it, if it makes sense, if it's doing the right thing, then we may want to pursue that. And then the trump card that seemed to hit that we had to deal with in all of our jurisdictions were political realities, and that was going to have some impact on decisions that were made.
Any questions of Kevin?
And then from a self-preservation standpoint, we all ask the question, is this a hill we want to die on?
Right.
So
sure. That's a frequently asked question these days. I really appreciate the second thing that you include, and that being, is it the right thing? Looking beyond mandates. So many of the courts that I'm working with, I'm afraid, don't ask that question enough. They don't include that in the mix of discussion or the criteria anyway. So I'm glad to hear you say that. Anyone else, please? Okay.
We talked about pre-existing hierarchies with case types that might already exist in the court and trying to take that and apply it to the new situation, but then also trying to decide if there were other classifications that you could look at your docket and say, okay, is this an appropriate time to reevaluate the time we're spending on felony versus misdemeanor versus domestic violence, children's cases, similar to what Kevin's group said, trying to parse out along a set of predetermined criteria which cases we're going to get your focus, your resources, and your attention.
And did you all have to suspend, I don't know what court you're with, did you have to suspend certain case types?
Absolutely.
May I ask which ones? I don't want to put you on the spot.
No, that's okay. I don't work there anymore.
Well, that's good. I don't want to put people who are working there on the spot. So let's just, we can forget that altogether. So I didn't mean to put you on the spot. Okay. For example, I know there's some states in New England that suspended civil cases. Yeah, that's what you did, right. You rescinded habeas corpus. Okay, the Constitution's not a rumor. Hey, I'm a Southerner too. Well, that's fascinating. Has any similar experiences here? Any courts here eliminate just or suspending hearing courts for a few months of any type? Anybody else have to do that? Well, I know for a fact that there are several states here in the last 3 years that have suspended civil trials, which to me is astounding. But they came to their own conclusions as to, what business are we really in, what are our priorities, and how to do it. And as you all have just shared, it's a very difficult discussion. It's not academic. It is very real. And so the constant question we have to overlay on all this discussion is, why do courts exist? You've seen this list. You've probably seen it 100 times. NACM devised this list when asked years ago, divining what the long-term curriculum would be for you. They started with this. What are the purposes of courts? When we have smaller groups, I ask them to try to rank order, just not that there's a right answer, but just the exercise of going through how would we individually prioritize these. And I get some in the workshops, I get fascinating answers. And there's generally no accord, but if we ask ourselves, using that list, why do we exist? It helps us get our hands around that overwhelming difficulty of answering the question. One of the best answers I ever got was from a judge after a fairly robust debate, and he said, and it made a lot of sense to me. He said, depends on what docket I'm hearing that day. If I'm hearing a criminal docket, it's protecting individuals against arbitrary use of governmental power, hands down. If I'm hearing a civil case, and then he made an argument for a couple of others. But it can be situational, it can be contextual, and I'm telling you, it doesn't just change from state to state. This changes within your courts, within a state. So it's not an easy dialogue to have. But the takeaway from the first prong, which is revisit our core, who we are, why are we unique, why does the world look to us, why does the country look to us as an institution, as a leader? If we ask ourselves that question, the final takeaway is, and I do believe this, that even in times of scarcity, if we can put purpose in our work, if we can remind our folks the incredible values we represent, we will get the commitment, we will get the creativity from our folks to problem solve, even when you have not had, as one of the folks I was talking to this morning, has not been able to hire a person for the entire state in 4 years. When you can still get that commitment and creativity when you can't give pay raises or you have forced furloughs. By merely echoing and reminding our folks who we stand for. Secondly, we suggested that if we can compare today's transformative courts to courts who may not be as transformative, what are the defining characteristics? What are the differentiating things that they do that other courts don't that allow them to adapt and transform? Those of you who are not ashamed to admit it, how many of you were in the court system 15 years ago? Raise your hand. Oh my goodness, that's wonderful. That is fantastic. Fantastic. Anybody, please just shout it out. How would you compare the works of your court then to today? Just yell it out if you can. Smarter. Better looking. Busier. Thinner. Like I said, better looking. Helping the community. Well, that's a big one, isn't it? Self-represented litigants. Oh, yeah. Progressive. Gosh, who would have used the word progressive to describe courts 20, 15 years ago? I wouldn't. Faster paced, more efficient. I'm sorry? More tech. How about, let me go back to the relationships with community. All of those are good answers. Just in the last, well, since 2007, when the ABA revised the canons of conduct for judges, just since then, I've seen an incredible shift in the demand that judges and court administrators are asking, give us skills to be able to collaborate and communicate with our community. Because we want to help the courts. We want to help our communities, rather. That's a kind of dialogue and self-realization that not many courts were doing 20 years ago. So one reason I'm asking this question, because I think it sets up, based upon my experience, having worked in what I thought was a progressive court, even back then, 20 years ago. But comparing courts then to what I've seen the last few years, here are just some observations I've made. It's not a complete list. It's not even a right list. It's just what I've observed. You've already hit on some of this. Some of these came out of your mouth, not mine. Problem solving. Independence through collaboration, not isolation. Speaking of which, for the first, in 2007, when the ABA canons for judicial conduct were amended, for the first time there was an official comment by the drafters, and you can read it, and I'm paraphrasing it, but it said, we want to make clear that court or judicial collaboration in the community is not only ethically permissible, this revised comment is hereby telling you, be encouraged to do it. Be encouraged to do it. Continuous learning. Now that doesn't mean sitting here and listening to some needle-neck guy like me for an hour and a half. It's not going to conferences, although that's good, or continuing education. That's good, but that's not what I'm talking about. I'm talking about understanding and having a communication within your court, and hopefully within your entire court system, observing the impact and effects our decisions, our re-engineering has on the rest of the system. The analogy I like to use is the court is like a big balloon that you can't get your arms around. Let's say it's half the size of this room. My observation is transformative courts don't just make changes, they analyze the impact and effect the change has on the rest of the system. And by metaphor, by pushing really hard on this part of the bubble, the balloon, those who are not transformative courts don't try to examine or understand that when you press there, you come over here, there's a bulge in the system or even in the court that I can't see from being over here pushing on it. Continuous learning means transformative courts are always looking to see the impact of their actions on the other operations within the court and the system, and then seeking feedback on why that is, and then making modifications to where they and how they push the bubble. That is one thing I think that has really allowed transformative courts to stand out. Strategic focus, avoiding fads. As I prefaced, much I think of when we talk about re-engineering courts, not the majority, but a lot, is, and I know this is going to be really unpopular, and I know it's going to upset some of my colleagues, but it's the truth. Some of it is mere jargon for court consultants to get more work. Today's approach, today's new solution, they'll come up with something, I'll come up with something, to be honest, another year from now. But transformative courts look at the long-term impact, not the short-term. And when we talk about ethics today in the workshop, the issue what puts courts in a bind is when people talk about cementing ethics into our organizations, they often go to the right versus the wrong. Well, listen, our mamas and daddies told us the difference between right and wrong. You don't need consultants to come in and tell you how to make right versus wrong decisions. Where most of the courts right now are, especially in this time of scarcity, is trying to make right versus right decisions. And something's going to hurt and give. There are very few right versus wrong decisions we in the courts have to make right now. But if we look strategically and think of ethically, what are the long-term impacts on our decisions? You mentioned number 5, the fast pace of change. They deal with it. They take risks. And this goes back to what one of our participants said earlier. I don't think anybody would have characterized courts 15 years ago as being risk-taking courts. But I'm telling you one thing, the Philadelphia Court of Common Pleas took a big risk when they said, hey, look, when the downturn in the housing market was going, we're going to lose tens of thousands of people leaving their homes. It's going to hurt our tax base. It's going to hurt our service. It's going to devastate our city. What business are we in? We have a role in saving and working out those mortgage foreclosures and getting everybody at the table to talk about it, to have a workout. And they did. And they saved tens of thousands of homes and the tax base. Remarkable story. Reentry courts for fathers getting out of prison. We see these in Texas, Kentucky. There are a couple of other states that I can't recall. And now they're doing evaluations of the efficacy of it. They're seeing over 150% increase in the number of contacts these men, primarily men, are having with the children that they've never talked to, getting jobs, making a contribution to the community, being a taxpayer. Remarkable risk taking and trying to make those types of courts work. And DUI courts, drug courts, do I have anybody from California here? Okay, you will remember this. Call me a liar. I think it was 3 years ago, may have been 4, but I think it was 3 years ago, your governor, Schwarzenegger, had surveyed thousands of Californians. And they said of all the services, of all the public services, not just courts, but all the public services we offer, and this is during economic crisis for California, what one public service are you willing to pay more taxes for to keep? You know what the number one response was? Drug and DUI courts. Not better transportation, not better education, DUI and drug courts. Because there were some folks out there years ago that said we ought to take a risk. What business are we in? What can we do better? Taking risks. So now I'm going to show you a list, and I want you to compare the left-hand side of the ledger with the right-hand side of the ledger. And I want you to ask yourself, keep score. For every one on the right that you think more accurately reflects who you are as a court, as opposed to the right. And I want you to keep track. Transformative courts, in my opinion, these days, well, let me just back up. This side of the ledger, perfectly good, perfectly necessary. I encourage it. When times are static, that's when you need management. This side of the ledger represents typical, traditional court management skills. The right side represents those that transformative courts are using. Let's go through them very quickly. Conversation rather than command. Not just with employees, but with the community, with people outside of the fishbowl. We in the courts do live and operate in a fishbowl, and the fish often don't know that their water is dirty, that needs to be cleaned, that we need new rocks. We need some fish we need to throw out of the bowl. But folks standing outside of the fishbowl looking in say, yeah, Mary the fish needs to be thrown out. By the way, this is the most important thing that I'm going to tell you all morning. At the break, Mary from Duluth said that I should make an announcement that she was in bed and asleep by 10 p.m. last night. So we square, Mary? Conversation. I've worked with various AOCs many years ago when I first started court consulting, where the model typically was the AOC office had the answers, and they'll tell you what your opinion is. Now we're seeing a much more collaborative model, helping others from the bottom to collaterally, horizontally, find the answers. We still need this. Technical administration skills, still highly sought after and needed, again, especially during static times, not during dynamic, challenging times as much. We need to have more informal influence. Collaborative, finding shared resources, not fighting for scarce resources. Continuing the ledger. So how many did you score on the first one? Add these to that score. Find meaning in court's work rather than gathering facts. As I said earlier, if we as court managers can help the folks that surround us and also who we serve find meaning in their work, they will be creative. They will problem solve. They will have commitment in times of scarcity. We talked about adaptive, anticipate changes, rather than waiting for it to come to us, and gosh knows we've got a lot of stuff coming to us, at us, we anticipate. I think we're seeing more strategic planning in courts now than I've ever seen in the last 20 years. Obviously, you've heard this a million times. We're becoming flatter. We're linked, not just within the court system, but extrajudicial agencies are having fresh new dialogues about how to solve the problems. And you've already heard me talk about learning strategies using the balloon. Just quietly ask yourself, how'd you score? If you scored 6 or more on that, I think you're really well along the way. Below 6, you may want to have a dialogue about, or maybe an internal conversation, are you using the right approach? Are you capable of being a transformative, adaptive court? Any questions? I've been talking a long time, and I'd much rather give you the reins. Any questions or comments before we go further? Okay. I get paid by the word, so I'm fine. So the third prong that we discussed in being able to adapt and be transformative is how do we create a highly performing work team? If there's one thing that I believe more than anything else is people will follow the person before they follow the plan. virtually always. It doesn't care whether it's in your church, your moose lodge, your racquetball club, your court, your elected officials. They follow the person before they follow the plan. The other thing that I think we're as a whole doing a much better job of doing, and thanks to the great work of the National Center for State Courts, who back in the 90s really refined and developed trial court performance systems, as well as core tools. I'm seeing courts more and more use that routinely. Because if we can't measure, if we can't come back and demonstrate that what we're doing is making a measurable difference, then inspiration will only last us so long. We've got to show results. And when I get to effective change management skills, one of the things I'm going to suggest to you that we need to do right away to have an effective change management strategy is to create short-term wins, to demonstrate that what we've inspired people to do, sometimes beating them over the head to do, is making returns. And I'll talk a little bit more about that or in our workshop. But high-performing work teams, they not only inspire, but people understand how that inspiration translates. This is a true story. This is actually fairly recently. I was working with a state court AOC, and no, it's not Virginia or Utah. By the way, I understand there are a couple of Salt Lake folks here. Where? Please let me talk to you before we leave so I can introduce myself to you. Now that I'm living in, man, that is just a jaw-dropping beautiful state, isn't it? It's just absolutely awe-inspiring. Yeah, it's a beautiful state too. Are our goals understood and measurable? Because there has to be feedback. We can only inspire so far. But to do this, it takes more than technical adaptations. It takes more than turning the screws. It takes that very elusive, hard to describe thing called court leadership. In your groups, I'm going to ask you to come up with the two most important leadership qualities you want. It can be of your court leaders, it could be your community leaders, it could be your national leaders, it could be in your church, social groups, I don't care what it is. You go to any place you want to go. I want you in a group to come up with the two top characteristics of leaders. Please do not list communication. For the purposes of this, we're going to count that as a skill and not as a leadership quality. So don't include communication or listening skills. Take about 5 minutes and come up with them, and I want to demonstrate something to you. Okay, for sake of time, I'm gonna cut you off. I said 5 minutes, but I don't think they'll give us a chance to cover a couple things and also to allow you to hear from each other. Just shout out. I asked you for 4, but for the sake of time, what were the top 2? Just shout out. Honest, forward-looking. And a sense of humor. Anybody else? How many others said in your top 4 or top 2, honesty, integrity, visionary? Raise your hands. Trustworthy. Good. The reason I asked you to do this is to prove to you that this is not an academic exercise. Every few years, various companies, research factories ask thousands of Americans the same question I just asked you. And virtually every year it is always the same. You might see a couple of these flip-flop. I heard a couple tables say inspiring, that's in there. But honesty is always number 1. Integrity, trustworthiness, always. And this has practical implications for court management during these times. Because we are asking people to change and to sacrifice, one or the other. Those are mutually exclusive. Sometimes change does not necessarily require sacrifice, but all too often it does. And when we do, it raises basic fears of security. A lot of fears. Am I going to be worthy? Will I remain competent? Will I become relevant as an employee? Will I be fired? If they know, and if you have a track record of being honest and trustworthy and telling them what they need to hear but not what they want to hear, you will get the commitment. With some resistance, you will get the commitment ultimately. It may be a hard row to hoe, but without it, without that one characteristic, people are going to sabotage you at every opportunity. So that is a practical implication we cannot overlook. There's so many leadership workshops and conferences out there that I think sometimes we forget about what it takes to do some of the things we're talking about. And without these things, you can't. What I find interesting when I start working with organizations other than courts, I wanted to look at what some of the ethical values are of human beings. And the Institute for Global Ethics actually did a worldwide survey of all types of cultures and countries to find out what, if any, are the universal maxims, the universal shared characteristics of ethical values that people want. And again, trustworthiness. But also, this is what surprised me when I first got into the research. Compassion, empathy. How does that translate? High-performance teams have a sense of compassion and empathy and understanding of the practical implications and impacts it's going to have on their community and the people that come into their courts. It goes into the equation. It's like what Kevin said when he was talking about how they prioritized. They pretty much said, are we doing the right thing? How's it going to affect our people? Not just a constitutional mandate, but compassion, empathy, understanding. You probably recognize some of these folks. There are certain characteristics of let's say, high-performance teams and others that are not so high-performance. I'm going to run through them very quickly for you. Consensus by general agreement, but let me say something that's, I think, very important. I think I've worked with too many court teams that have paralysis of consensus. They don't move unless there's absolute consensus, and generally a consensus, a complete consensus, often will hamstring your efforts. Sometimes you have to pull the trigger. People would rather be listened to and understood than agreed with. Teams that don't make personal attacks but have frank criticism. I'm working with a group now, and I won't say who it is, and they've got some team dynamic problems, and the person said, oh, you're going to have a hard row to hoe because they're always fussing and disagreeing. I go, okay, well, I'll sit and observe and see. A week later, they say, what do you think? I go, this is a great team. Have you listened to them disagree? Have you listened to them fight? They have almost a virtual complete trust in each other. They can say, not harsh or hard, but frank and real. Criticism of each other, holding each other accountable when they're not pulling their share. And they will have some loud disagreements, but not abusive. And guess what? I don't know if you've been watching them. They go out to lunch every day, laughing. So disagreements and frank criticism, I think, is a good hallmark of a high-performance team. Clear assignments, you know that. Examining how well it functions. Here's something interesting I want to focus on, not unduly, and I underline unduly, deferential to the leader. The team focuses on getting it done, not on licking somebody's boots. That decides whether they're going to get a pay raise, like they're ever going to see a pay raise again. but not unduly deferential. When I see a team that treats their leader in the hierarchy, in the formal hierarchy, unduly deferential, I know right then and there I've got a major problem. Though I love it when they do it to me. This is critically important as well. Individual goals mesh with the court's. This goes to the essence of why we need to repeat over and over again what our core values are as a court and as an institution. Because during hard times, when we can create an environment, a work environment, whether it's just a small team or a whole state court system, when our personal goals as a human being, when our values are consistent with those of the top values of our court, for what we stand for as an institution, it meshes. And it builds a commitment and an energy and a synergy that is inexplicable to me. Let's skip around here. Members listen and don't jump tracks. They stay on task. And one reason is because their team tasks are understood and accepted. And I think if one of the most common things we can create to improve high-performance court teams is to make sure people know not only what their task is, but what the measurable outcome is going to be at the end of the fight, at the end of the day. I would suggest whenever we start re-engineering anything, we start forward and work our way backwards. We start by saying this is what it's going to look like, and this is what it's going to do in measurable terms, not just lofty, improve justice, improve access. We need to have the conversation with our folks. This approach is going to cut delay reduction by 30% within the first 9 months. In those type of objective, measurable terms, and repeat it over and over again. As I mentioned before, comfort with disagreement. I want to reiterate that point, because that is a true hallmark of a healthy, high-performance team. What gets in the way, and I'm going to let you go in 1 minute, what gets in the way are 4 basic fears whenever we have to re-engineer or deal with change management. This is a $10,000 lesson that I learned. We all fear death, of course, abandonment, we fear rejection, we fear all of those things. We're afraid we're going to not, if we don't succeed, a lot of things, we get it blown out of proportion. In the workshop, we're going to talk about how to deal with the fear of abandonment, rejection, failure, and death, and how to have a frank dialogue when we have to have change management or re-engineering, to have an honest, not glossed over, syrupy conversation, but a frank and honest dialogue in our teams that can overcome that. And we're going to look at one thing more than anything else that sabotages that change. If I don't see you for the rest of the conference, let me tell you it's an honor to have served you. You're doing great work. Thanks for staying in the foxhole and keeping up the good fight. See you.